Hello everyone, welcome to Shorthand Battle. I am Divya and I am going to dictate you a legal passage of 500 words at the speed of 100 words per minute. So get ready for the dictation. 3, 2, 1 and go. The only conclusion recorded by the inquiry officer is that since the petitioner did not cooperate with the disciplinary proceedings and that from his conduct it is clear that he does not want the proceedings to be concluded, he had no option but to record a finding that the charges stand proved. It is trite law that even if disciplinary proceedings are continued and culminate ultimately ex parte, the inquiry officer is under a positive obligation to record his satisfaction with respect to the charges levelled against the delinquent employee with reference to the evidence based upon which the employer seeks to take action against the employee. Even this rudimentary and settled principle was not borne in mind by the inquiry officer. The mistake committed by the inquiry officer, as noted above, was reiterated by the disciplinary authority inasmuch as neither in the order dated 24 April 1998 nor in the order dated 13 August 1999 has the disciplinary authority recorded any independent satisfaction with respect to the guilt of the petitioner based upon the evidence or material on record. This, of course, subject to the caveat that the failure of the inquiry officer to record his conclusions on each charge is not a flaw which could perhaps have been cured by the disciplinary authority for the first time. That leaves this court to deal with the last submission of Shri Mishra that the judgment and order of this court dated 2 November 1995 conferred authority upon the corporation to continue and conclude the inquiry despite the superannuation of the petitioner. It becomes pertinent to point out here that the judgment and order of the court dated 2 November 1995 required the corporation to conclude the proceedings within a period of 8 weeks therefrom. Admittedly, this report of 8 weeks had expired long before the passing of the orders impugned. This court has not been referred to any material or circumstance which may have constrained or injuncted the corporation from proceeding ex parte and concluding the inquiry in case it was its contention that the petitioner was deliberately not permitting the conclusion of the inquiry and adopting a procedure of non-cooperation. From the facts notices herein above, it appears that the corporation fell into deep slumber post 30 April 1996 till it issued a notice on 3 February 1998. Even otherwise, this court finds itself unable to view or read the order dated 2 November 1995 as conferring or clothing the corporation with jurisdiction to continue with a departmental inquiry against a delinquent employee post his retirement in the absence of any statutory provisions, rule or regulation conferring such authority upon the corporation. The last significant issue which must be noted is this. Admittedly, the show cause notice was dated 22 April 1998. This notice required the petitioner to submit a reply within 15 days. Even before the said period could expire, the impugned order came to be passed on 24 April 1998. Stop.